This is a case I've been covering for a few years now. It's full of controversies and heartache. It involves one of my absolute favorite attorneys, and the arguments in this case are very similar to arguments made in the Blake Lively case. I'm going to deep dive the topics here, so you'll learn a lot about court decisions on the very topics that you find in the Blake Lively case. But it will also give you a better understanding of lawsuits and trials. Not on my word, but from the actual cases that I'll share. That's the best authority. Come and be my fellow classmates on this learning journey. In the last update in this conspiracy case, we talked about Greg Roman, the guy who has exclusively reported on the Middle East for his entire career until he became very active reporting on a family in the low country of South Carolina that no one outside of the area had ever heard of. Or at least we hadn't until Alex Murdaugh went on trial for killing his youngest son, seen here purchasing alcohol on the day of the boat crash that started all of these events, and his wife Maggie. We saw a list of people suspected to be the connection between Greg Parker and the private investigators who were providing answers to their interrogatories. One of the last documents we considered was from this reporter, Greg Roman, where he was vigorously fighting to quash a subpoena for his banking information and other things. That was a big clue, because he was the only one from the list that was followed up on in any of the filings. This is what's earned him a spot on the thumbnail, right here next to Greg Parker on the right. Now we have more filings that are also centered on him, making it appear even more that he is, in fact, the connection the PIs were referring to. Let's get started. I'm Cassidy O'Connell, and this is 4.5 years of Deja Vu, a conspiracy case update. Part 1, Impleader. Welcome. There's a document referred to as being filed on June 23rd, but it doesn't show up on the public docket. So we're starting off with the filing on June 27th that first speaks of this document. It's by an attorney that works with Mark Moore on this case. She's another one that disappoints me greatly, especially because she's a she, and as a woman, I would wish for better choices in selecting clients that you'll stick your neck out for. But as with Dick and Mark Moore, she's a bottom feeder when it comes to selecting clients to represent. That's my opinion, Deb. Don't subpoena me. She's Deborah Barbier, another one I've seen in person in action when she was defending Alex Murdaugh's co-conspirator Corey Fleming. You know, the guy who helped Alex steal from the sons of Gloria Satterfield, the family's housekeeper and nanny who'd helped raise his sons. She died in a freak accident on the Murdaugh's household front steps. Of the 3 people who were supposedly present during and after her accident, no one is still alive. Alex took every penny of their settlement while watching them lose their home. Even worse when you learn that one of her sons is a vulnerable adult, and the home that they lost was in fact Gloria's own trailer. Corey helped out by representing Gloria's sons, but he didn't represent them at all. In fact, he was there to ensure that Alex was able to steal every penny of their settlement and get away with it. He knew their case was settled, but never informed them. He accepted the payment and handed it over to Alex. If that's not bad enough, he also helped Alex steal from a woman who was in a terrible accident that turned her son quadriplegic. While she herself was undergoing no less than 15 surgeries, her son died when his machines were mysteriously unplugged at his care facility. Frankly, it bothers me so much that no one has investigated this death. This boy couldn't move. How was his machine unplugged? Even stranger, it was within days of Alex finding out that the suit was being settled, but before his mother could get him moved into a better facility. These are the 2 families that Corey helped steal from, and Miss Barbier not only represented Corey, but she's currently helping him appeal his conviction after he pleaded guilty, but then had buyer's remorse when he got a sentence he didn't care for. And now here she is, defending Parker, a billionaire who has trouble keeping employees in his convenience stores, which leads to a high turnover rate. That in turn leads to insufficient training and little company loyalty. It was one of such stores that we see in the picture where Paul Murdaugh and his friends purchased the alcohol that led to the fatal boat crash. If you can't keep up with proper protocols, let your liquor license go. Nobody's forcing you to sell alcohol, sir. Maybe pay your employees better instead of taking huge profits that made you a billionaire. I don't know. Seems like it might be worth it in the end. All of these accusations we're talking about here today are alleged, with the exception of Alex and Corey's crimes, which they've both already been convicted of. In addition to Alex and Corey's convictions, the boat crash has been settled for over a year now, settled in favor of the Mallory Beach family. These conspiracy charges have not been tried in a court of law yet. So as I said, when I speak of this case, it's all allegations and opinion at this time. In this filing, she's worked up over this June 23rd filing that I said is not on the docket. There is one asking for a third-party complaint that does get filed in July that we'll consider next. But here she comes in something I've never seen. A filing of opposition before the actual motion itself has been filed. In fact, she beats it to the docket by 3 weeks. In her arguments, she first mentions the length of time that has passed, which is rich, because it's her and Mark, the time-waster Moore, that have caused delay after delay to this case that the Beach family surely wanted resolved a long time ago. As stated before in updates in this case, this is also the third judge that's been assigned. So these delays were not caused by plaintiffs, who've been trying to get to discovery for all of these years. And now to the point where Greg Roman and his company make an appearance on the docket again, leading me to guess that he is the one, in fact, that's thought to be the link between the PIs and Greg Parker. This case hasn't had all the leaks that the Blake Lively case has had, so we're surviving on fumes. But we have enough to go on to justify this update today. We have some terms that we've heard in Blake's case, such as indemnity agreement. Remember that came up with Isabella. We also have straw man, conspiracy, PIs, and this time a real smear campaign, a traceable campaign with bot farms, a journalist who's alleged to have been hired by Parker and in turn apparently hired these PIs and later instructed them to reveal the information they discovered to news agencies and to law enforcement. We discovered that in their answers to interrogatories. This is what a real smear campaign looks like. But this indemnification is at the heart of this filing. Remember, an indemnity agreement holds someone harmless, or takes the responsibility should something go wrong in the course of doing the job that they were hired to do. Isabella was covered by Wayfair, and here, this journalist, Greg Roman, allegedly, we learn, indemnified these PIs. Another very strange development. Why would a Middle East reporter suddenly cover the Murdaugh family? And long before the rest of the world had heard of the Murdaughs. Even stranger, he's not from South Carolina. As we learn in these filings, he's from Philadelphia. So why did he hire PIs and take the responsibility to indemnify them during this work? Why would a reporter have them report their findings to law enforcement and other media? Most journalists like to have the story all to themselves. Why did he care to report it to law enforcement? Why was this story the one and only shift from the Middle East in his entire career? Very odd indeed. Now here's where we see that the document had not actually been filed, but it was only a purported consent order. So as I said, she's really jumped the gun here to respond. So much so that she doesn't even know what this proposal is going to say as far as what rule it will be based on. So basically, it's 9 pages of wild speculation and arguments in advance. So she speculates it will be based on Rule 15 and gives us a quote focusing on the bold text here, or by written consent of the adverse party, ignoring by leave of court, as a reason why a party may amend his pleading. In keeping with this rule, she of course mentions that it prejudices her client, a claim that she needs to prove to overcome this rule. Interestingly, she offers no basis for or explanation for how this will prejudice her client, other than generic statements of jury confusion. She goes on to say that as adverse defendants, Parker's does not consent, again ignoring that it says or, not and. So her client's consent is in fact not required, mentioning the prejudice that her clients will face if the amendment is allowed. She addresses that Rule 15 states, when justice so requires, leaving out the shall be freely given, and then proceeds to attempt to tear down every reason they could possibly have for getting this granted. She says they've not asserted why justice requires. They actually do. as we just saw her state that it's to join Greg Roman and his company based on an indemnification agreement with the PI defendants. It was only 2 paragraphs ago. How did she forget that? But here she has the gall to say that this should have been moved on over 4 years ago. In a later filing, we're going to realize that this indemnification just came to light when the court compelled discovery. She knows what counsel for the Parkers has put these guys through in these 4 years, where they've tried to block them from all discovery, repeatedly tried to remove opposing counsel, delaying this case, running to the South Carolina Supreme Court. As I said, they're on their 3rd judge. It's a miracle that they've not given up and that they've gotten as far as they have in solving this case. She makes a big deal out of this 10-day rule, but it's regularly overcome, and newly discovered evidence, as in this case here, is often given special treatment in lawsuits. But she leaves out all the good stuff in Rule 14. So let's have a look ourselves. Third-party practice. When defendant may bring in third party, at any time after commencement of the action, a defending party, as a third-party plaintiff, may cause a summons and complaint to be served upon a person not a party to the action, who is or may be liable to him for all or part of the plaintiff's claim against him. Isn't that what indemnity agreements are about? Liability. This is exactly what this rule is written for. The third-party plaintiff need not obtain leave to make the service if he files the third-party complaint not later than 10 days after he serves his original answer. Otherwise, he must obtain leave on motion upon notice to all parties to the action. For the sake of time, I skip the parts that don't pertain to this case. Joinder as plaintiff or defendant. Upon motion of any party or on its own motion, the court may order that a party designated as a third-party defendant be joined as a plaintiff or defendant under Rules 19 or 20, when the ends of justice and efficiency in proceedings would be served thereby. In event such joinder is ordered, designation of such party or his pleading as third party shall thereafter be dropped. Let's look at this note. These rules, 14A through C, are substantially the same as the federal rule, except for the omission of references to admiralty and maritime practice, and the addition of Rule 14C as to joinder. There is no counterpart to third-party practice in present state procedure, but the liberal state practice as to joinder and interpleader render the procedure less novel than appears on its face. The development of third-party practice in the federal courts over the years has led to more use of joinder under Rules 19 and 20 rather than increased use of third-party practice. Therefore, Rule 14C is added to encourage that result where appropriate. So federal courts would rather use joinder than increase the use of third-party practice. That's an important note, and we'll discuss the reasons why as we go through this. She mentions that it's well past the 10-day deadline. No one's making claims that it's not. And then she quotes from a case, saying a third-party claim may be asserted under Rule 14A only when the third party's liability is in some way dependent on the outcome of the main claim, or when third party is secondarily liable to defendant. This is exactly what indemnification is. It's about being secondarily liable. And that's exactly why Greg Roman is being added. She cites Beach v. Hudson. When you look it up, it's known as Beach v. Smith. But this case is a whole different ballgame. Now, because there are so many different circumstances possible in a case like this, it's why it's left up to the court's discretion, because the set of circumstances in each case is different. She quotes another case. If you've been watching me for a while, you already know that I love to deep dive the cited cases. Why? Because it helps me understand the court's decisions. Every court's decision becomes a sort of law of its own called case law. It's especially true of higher court rulings, such as rulings made in courts of appeals or in Supreme Courts. The more of these that you become familiar with, the better you can project the right outcome of future cases. Now, this case she's quoting from is a complicated real estate case that ends up in the Court of Appeals. She brought a third-party complaint against third-party defendants Vernon Smith, Jerry Hawkins, MacHawk Inc., and Maybohm Realty. That's a lot of third-party defendants. Her third-party complaint ends up being struck, and that's what she's here appealing. Now, this summons and third-party complaint, in addition to being against all of these different defendants, she alleges 7 causes of action. If you're used to watching, you also know how much I love when the word wanton appears in a legal document. So let's take a moment and appreciate that. Looking closer at her causes of action, each of the first 5 of them, she seeks actual and punitive damages. The 6th cause of action, she seeks only actual damages. And the 7th cause of action, she seeks treble actual damages and attorney's fees. With very good reason, the appellate court agreed that this was too much as an impleader. But was it as simple as the case we're considering? No. Is it similar enough to be listed here as a comparison for case law? No. As the court says in their decision, when considering a request to strike or to sever a third-party claim, the court may properly consider the effect the additional parties and claims will have on the adjudication of the main action, whether continued joinder will serve to complicate the litigation unduly or will prejudice the other parties in any substantial way. Here's what they say. In our view, the assertion against 4 additional parties of 7 additional causes of action involving, as those causes of actions do, allegations, among other things, of fraud, negligence, recklessness, outrage, and unfair trade practices, treble damages, and repeated demands for punitive damages will unduly complicate the adjudication of the relatively simple contract action that's brought by the plaintiffs. So they're saying this joinder is more complicated than the original lawsuit, and that if this was all tried together, it would all but submerge the plaintiff's claim. So they found that the trial court did not abuse its discretion when they granted the motion to strike. So her attempt to join them was not about anything simple like an indemnity agreement. It was very complicated. But this is an important citation here. A third-party claim may be asserted under Rule 14a only when the third party's liability is in some way dependent on the outcome of the main claim or when the third party is secondarily liable to defendant. That's the quote, and that's exactly the situation with Greg Roman. And I don't understand how she misses the point so completely. If an indemnity agreement does exist, then it absolutely makes Greg Roman as a third party secondarily liable to the PI defendants. It's the most classic example of secondary liability, so I don't understand her argument here. She then mentions that any party is given the right to move to strike. And the footnote is just cases that spell out the obvious that when there's no state law that covers the situation, a state turns to federal law. This is normal, but of note, as we saw, federal laws are broader and more open. She then moves on to 4 factors that are considered in a scenario in another cited case, Cody versus State Farm. Let's see if this one applies any better than the last one. This is a case about damage to roofs of several people in the same community. Some of the homeowners were approved for total roof replacements following a series of storm events. Plaintiffs' claims were singled out and denied after an altercation between a State Farm claims adjuster and a representative of the roofing contractor who constructed plaintiffs' roofs. Jones was the adjuster, and he instigated a verbal altercation with Alex, who was the contractor. In fact, an adjuster had to put his own body in between them to stop the altercation from becoming physical. After this altercation, the plaintiffs contend that Jones improperly denied and continued to deny their claims. So the defendant here is moving to sever the plaintiff's claims, saying that they don't relate to or arise under the same transaction or occurrences, that they'll require 3 mini-trials within one proceeding, and that this doesn't serve judicial economy, which will result in jury confusion and prejudice to State Farm. Each roof was insured by a different policy, and the damage was alleged to have occurred out of multiple storm events, not just one, so who can say when the damage occurred to each roof? They also say there's no common transaction or occurrence for a purpose of permissive joinder. The policies themselves are handled under different insurance claims. And here's where this 4-pronged standard came from that she cites in her filing. 1. The court should consider whether the issues sought to be tried separately are significantly different from one another. 2. Whether the separable issues require different witnesses and different documentary proof. 3. Whether the party opposing severance will be prejudiced if it's granted. And 4. Whether the party requesting severance will be prejudiced if the claims are not severed. What a difference when you have multiple different roofs with different damage, different policies, different dwellings, and of course it didn't pass this test. On the other hand, the person who hired the private investigators, who is a possible link connecting the defendants in this case, is not significantly different from another. It's an alleged conspiracy where all of these people worked hand in hand. Some of the other factors in this court's decision, besides of the ones we've already mentioned, are that the roofs were of different ages and suffered different hail damages. And so it was decided to be improperly joined. But what a struggle to try to see how this relates to this complaint. She makes the bold claim that the indemnity issue is certainly not indispensable to the resolution of this lawsuit. She brings in Rule 19, again, not knowing if this is something that's even going to be mentioned in the motion because it's 3 weeks from being filed at this point, and states that potential indemnification of a party is not a legitimate basis for a joinder of a third party under Rule 19, and quotes from the next case. Why not wait until the motion's filed so you can argue the appropriate points? This isn't like a track runner who just started running before the starting shot. This is a runner who did a few laps before her opponent even took their mark. And guess what? Those laps don't count in the race. Are they planning to add him under Rule 19 as indispensable? Is that based solely on the indemnification agreement? Is he added under the Rule 14 standard of secondary liability contingent on outcome? It's really just so bizarre to have this whole filing before she knows the answers to these questions. But let's talk about the Rule 14 standard. Remember, the federal rules encourage this result. We already saw that in the actual rule, and we're going to see more on that. But next, she cites, like I said, this Weatherford case. Let's look at that one. This is a case of toxic wastewater contaminating a creek and plaintiff's property. It was brought on by a hurricane that flooded a plant. This plant had basins that were full of this PFAS-containing wastewater, stored in such a way that when it was flooded, it emptied it out into this creek, ultimately into this river, and finally onto plaintiff's property. Now, in this lawsuit, they didn't name the factory, they named the makers of these toxins. DuPont, the Chemours Company, 3M, Daikin, Mitsubishi, and Polymertrade. And so defendant Daikin says, wait a minute, all we did was lawfully sell this stuff to this plant. Those injuries occurred because of the plant's negligent conduct, the method in which they chose to store it. As they state in this case, this is the exact problem that Rule 14 is meant to remedy. Rule 14 of the Federal Rules of Civil Procedure provides that a defendant as a third-party plaintiff may bring an action upon a person not a party to the action who is or may be liable to the third-party plaintiff for all or part of plaintiff's claim. And we see they use the word Impleader in there. What did the court decide? We see the decision right here. And I apologize for the strange way that it appears. If you're not familiar with PACER, some orders that are given by the judge come in the form of an actual filing that you can read. Looks like a regular legal document. Others are not. They're not available to the public to download. But you will instead get this little box that explains what was said in the order. And this is what it looks like on PACER. We see this document number is 118, and right there, 118, motions for leave to file third-party complaints, granted. He grants it all, 117, 118, 119, and then amend and correct the complaints to add these names to 69 and 70. He tells them to be ready for a scheduled conference to discuss any steps they believe would help ensure the efficient progress of this litigation in light of the filing of the third-party complaints. So, he recognizes it's going to take a little adjustment, but when he weighed it, he determined that it was the correct course of action. Which leaves me to wonder why she cited this case, because this case goes against her and what she's asking the court for. And this case is actually a lot more similar to the case at hand, where a third-party defendant brings in someone else who is also liable for the harm. Next, she cites two more cases. One, Lewis v. Clark. This one made it all the way to the U.S. Supreme Court, and the case it cited from was Pettiford v. City of Greensboro. We're deep diving these to show that sometimes attorneys pick a small phrase out of a case's decision that seems to bolster their case. It might sound good on the surface, but if you don't dive in to see what the case is actually about, you don't know that it's actually not supportive for their argument. She takes this sentence that says contribution and indemnity are not legitimate basis for joinder of potential joint tortfeasors under Rule 19. And joint feasors are just persons who committed a tort. Now this case, Lewis v. Clark, is the one that went all the way to the U.S. Supreme Court. The reason that it went this far is not over simple indemnity. This case is much bigger than that. So what's this case about? The Lewises were rear-ended on a Connecticut interstate by William Clark. He was a limousine driver that was employed by Mohegan Tribal Gaming Authority. He was transporting casino patrons when the crash happened. So the issue became that the lawsuit should be dismissed because the gaming authority that he worked for, who owned the limousine, had tribal sovereign immunity, and so he claimed that that immunity protected him. This was his main claim, that he was an employee doing his duties, and so he should have this immunity. Not only that, but the gaming authority should indemnify him if he lost. Now we see why this was such a big deal. It's not something that happens all the time. So what happened in the lower court was that they denied his motion to dismiss, saying that the lawsuit was against him personally, and so the immunity didn't apply. When he appealed it to the Connecticut Supreme Court, they reversed it, saying that the immunity did extend to him. The Supreme Court unanimously reversed that ruling and went back to the lower court's decision, saying that if you sue someone in their individual capacity, you're suing that person personally, not the government or its agency. So sovereign immunity doesn't apply. They didn't sue the tribe as the owner of the limo. They had sued him personally. And although his job was required to pay his losses, that indemnification didn't shift immunity, because the question that was at stake was who's on the hook legally for the accident, not who's on the hook to pay the bill. So though indemnification was a part of this, it was about whether or not it can shield an employee from a lawsuit if immunity wouldn't otherwise apply. So you can see this citing is ridiculous because it's not about indemnity as a reason for joinder. This is about the attempted misuse of indemnity to claim immunity. A very different argument. And now for Pettiford, the case that it's cited from, that's also put here. In this case, Pettiford was suing the city for wrongdoing by police officers. There were also federal prosecutors involved in this wrongdoing, and so the city attempted to join these prosecutors together with the police officers. And we start to see why the Lewis versus Clark case cited from here, because this is about immunity as well. This is about immunity that covers the federal prosecutors. So the city police were trying to join the federal prosecutors so that they could fall under their immunity. They also wanted contribution to help pay for any liability they were found to have. The court said that's not enough to force joinder. They tried to argue under Rule 19 that the federal parties were indispensable, but they decided that the federal parties might have useful evidence, but they weren't the only source, and therefore were not indispensable. The court determined that the lawsuit could proceed against the city without dragging the federal parties into it. Clearly, this case is also not about indemnity as a reason for joinder. This is about another attempted misuse of indemnity to claim immunity. So far, her case law doesn't apply, or is actually in defense of the joinder taking place. Let's see what else she's got. She continues by saying it's not at all certain whether Roman and Company's alleged indemnity agreement has any relation or connection to the allegations in plaintiff's complaint. No evidence that shows Roman and Company participated in the alleged conspiracy set forth in plaintiff's complaint and or the alleged services performed by the private investigator defendants relate to or arise from the alleged conspiracy set forth in plaintiff's complaint. Then she says, it is entirely possible Greg Roman independently hired the private investigator defendants to perform services unrelated to the Parker defendants. We've talked about this before, but let's repeat how very odd it was for Greg Roman, a guy who lives in Philadelphia, whose entire career as a journalist has been pro-Israel, reporting exclusively on the Middle East, to suddenly pick up this story as it was at the time of a boat crash in South Carolina, and give this long, detailed article about a family that no one outside of the Low Country had ever heard of, to hire these PIs to find out more information, send them to other media outlets. Again, since when do journalists want other media to tell their stories? They often get mad about this, actually. And then also to give the information to law enforcement. Doesn't that sound wild to you? It sounds wild to me. I mean, to what end? And then, suddenly, just as suddenly as he came on, he turns around, walks away, and goes back to reporting exclusively on the Middle East, never to repeat another story like this again. These are the things you find in a real smear campaign. She also forgets that we know about another case that was filed by yet another PI firm, a company called Inquiry Agency. They were hired to do the same thing that these PIs were hired to do. That agency was hired directly by Baker Hostetler, the law firm that Greg Parker used for his company. Just like in Blake's case, we see yet another huge law firm getting involved in shady moves for their wealthy client, just like Manette has done for Blake and Ryan. It really destroys one's faith in the justice system, doesn't it? But that's what we see here. We see the connection between Parker's law firm, these hired PIs, and Greg Roman. He and this other named reporter, Vicky Ward, went on to produce and appear in the Murdaugh documentary, the very documentary that used the photographs alleged to have been obtained by Parker's counsel from law enforcement that were aired in a trailer for this documentary. It was those barely blurred photos from that trailer that led to this conspiracy lawsuit. So attempting to pretend that Greg Roman was acting on his own in all of this, I would call one of the biggest jokes I've ever heard, except for it's not the least bit funny. Sorry, Deb. Your case is crumbling. What we're looking at here is the lawsuit by inquiry agency, where she tells of entering into a contract with this law firm to investigate Paul Murdaugh and his family, to gain information for what? To be used in a PR campaign to sway public opinion in favor of Greg Parker and Parker's Kitchens, who was being sued for the wrongful death of Mallory Beach. This is the smoking gun that Blake Lively's case is missing. We're going to come back to paragraph 7 in the next episode that talks about privilege. But how does one ignore this connection? In one case, we have Greg Roman appearing as the person who hired these PIs. In this case, we have the law firm that's hired the PI, but we have here in purple that all or nearly all of the investigation materials were shared with third parties, including but not limited to Wes Donahue and his companies, and reporters Vicky Ward and Greg Roman. How is this all not related? And this little picture is from Greg Roman's IMDb. We see the documentary listed right there. He's a producer, and so is Vicky Ward, who's also mentioned here as receiving this information. Wes Donahue is the self-proclaimed knife fighter who gets hired to sway public opinion. Now she comes back to her failed argument that the indemnity has no bearing on any question of law or fact, which is rich, considering what we just saw in Inquiry Agency's lawsuit. Greg Roman looks very much to have been a part of this conspiracy and smear campaign. But besides of that, let's look at her next citation, companion prop. Now there is so much going on in this case that I found an article summary so that it wouldn't take all day to explain it. This has to do with banks and assets and finance and things I don't understand. But there were bad investments made, and the U.S. Bank was being sued. The U.S. Bank made claims against third parties for apportionment, contribution, and indemnification for its liability to Companion. The third parties moved to dismiss the claims, and that was granted except for the claim for contribution. Then U.S. Bank filed an amended third-party complaint, adding this insurance management company as a third-party defendant. Now, one of the third parties also filed an answer to this complaint, and it contained 7 counterclaims against the U.S. Bank. The bank moved to dismiss the counterclaims. The insurance management company moved to dismiss the third-party complaint by U.S. Bank on the basis that the court lacked personal jurisdiction over it. Burns also filed a fourth-party complaint against the U.S. Bank Trust National Association for contribution, who turned around and moved to dismiss the complaint by Burns on the basis that the court lacked personal jurisdiction over it. Is that confusing enough yet? Is it any wonder that the citation for this case says many courts have ordered a separate trial for indemnification claims in cases this is important, like this one. This is not a simple, I hired you, so I'm responsible for anything that happens to you legally while you perform this action for me. You heard all of those counterclaims. Just like the earlier one, it would completely bury the original claim. So citing this here is just ridiculous. She next tries to further complicate it by making it out that this case, like that case, would be very distinct and separate, as if Greg Roman is only added as an insurance company and not someone involved in the conspiracy itself. It's so bizarre. So Barbier has presented the court with these messy, complicated cases that for the most part bear no similarities to this case whatsoever in an effort to make it appear that joinder is a big deal that's frowned upon by judges. These are all the cases, the rules that they attempted to use, how they attempted to use them, what the decision was ultimately, the reason for the decision, and how it compares to our case. The only one that was similar was this Weatherford versus DuPont. The one that was allowed and it was allowed because it was classic Impleader, where a third party may owe contribution and/or indemnity. Overall, not great case law to cite in this. Now let's take a look at my list of cases. It turns out there aren't a whole lot of cases similar to this one that's before the court, so the court is not going to have an easy time making this decision. For the sake of time, I'm not going to go through all the details of each case. It took me an entire day to do this research. But this first case, of First General versus Miller, is directly about Impleader based on indemnification basis. It was granted, but it was granted on appeal. So the lower court threw out First General's third-party claim, saying that indemnification wasn't proper because Miller alleged that First General was also negligent, and indemnity isn't available if you yourself were negligent. There aren't a lot of cases about this kind of topic, so it's not surprising that this happened. But then the higher court, the South Carolina Supreme Court, held that a contractor may implead its subcontractor for indemnity under Rule 14 because the contractor's liability is derivative of the subcontractor's work. And this is the relationship that we have between Greg Roman and the PIs that he hired. It is like subcontracted work. The court emphasized that mere allegations of the contractor's negligence do not defeat indemnity at the pleading stage. Only proof of actual negligence would. So here we have a higher court's decision than the court who faces this decision now. They will likely rely on this case to make that decision. The next case is Tetra Tech versus Sam Temple's Masonry. This case also directly sorts Impleader on indemnification basis. This was not in a state court. This was in South Carolina federal court. But their decision was, let's a defendant bring in another party who may be secondarily liable to them, as we've seen Greg Roman is if there is this indemnification agreement, meaning the new party's liability only arises if the original defendant is first held liable. Examples of when Impleader is proper: indemnity, contribution, subrogation, warranty, basically derivative liability. This could be another case that the judge pulls from to make his decision since it was federal court. Third, indemnity insurance versus Schriefer. This case also goes to appeal. The reason that it's important, though, is that it's often cited for Rule 14's purpose, and they state, Impleader is meant to prevent circuity of actions, letting indemnity or coverage questions be resolved in the same suit where the main liability is decided. So what is circuity of actions? It's a legal concept that describes complex, indirect, or roundabout legal process that results in multiple separate lawsuits when a single more direct action could have resolved it all. What this avoids is called piecemeal litigation, and the court was stressing that avoiding piecemeal litigation is a primary objective, so that when Impleader is possible, it's highly favored by the court. They stated Rule 14's policy that was to resolve derivative liability efficiently in one case as being the meaning of Rule 14. But the problem with this case is that it wasn't about just that. And so they say that it's not to give parties a free pass to short-circuit state proceedings with premature federal litigation. That was the reason for this denial. So what happened is plaintiff had already a state court lawsuit going, but then filed this additional federal declaratory judgment action. So the fault was found not about Impleader, and that's why it made these statements supporting Impleader, so that there wouldn't be confusion by the ruling. It was denied for attempting to bypass the state's decision with the federal one. So again, they denied it, but they wanted it to be clear that it was not because of the Impleader, that the Impleader was correct and the chosen course to follow. But it was this tricky bypass they were attempting was the reason that it was sent back to state court. Then finally, we have Wilmington versus Patel. They granted Impleader, and they reasoned that Rule 14 is meant for exactly this situation, when a third party may have to indemnify or defend a defendant. Even if indemnity isn't yet ripe, a duty to defend claim is, and efficiency favors resolving them together. So remember, preventing circuity of actions and piecemeal litigation. It was granted. This was also in federal court. So each of these cases, I think, will probably be used by the judge to make his decision. This one is the Fifth Circuit, but it recognized that indemnity is a proper basis for Impleader. In this case, the defendants Patels argued that another company, DATD, had promised in a contract to defend and indemnify them, just like this case, against claims like this claim brought by Wilmington Trust, and the court found that they plausibly alleged contractual duty by DATD to indemnify, and so Impleader was allowed. One of the arguments that people bring against an indemnity claim is that the claim is not ripe yet, before liability has been decided. But the court found that the duty to defend was ripe even if liability wasn't. And so they said that rather than denying Impleader, they allowed it and said it could defer ruling on indemnity until after liability was decided. Very simple way to deal with these situations that doesn't add all the prejudice and all the confusion and all of the extensive time that she's attempted to lead the court to believe that it would. So we can clearly see that these mostly higher courts do not frown upon Impleader for indemnity, but in fact welcome it because of its judicial economy. It avoids duplicative discovery, multiple trials, and inconsistent outcomes. It promotes efficiency and conserves judicial resources. So when you select cases that are more similar to this conspiracy case, you find that courts, mostly higher courts here, favor Impleader. And now she goes through the rest of her arguments. She kind of skims through these more quickly. She's still going through that list of factors, and she says that they require balancing the prejudice faced by the parties opposing joinder and the parties requesting joinder. She says joinder wouldn't prejudice the PIs at all, but that the prejudice faced by the Parker's defendants is immense. Now you would think that making such a claim that it's immense would involve a description of how it is immense, but her only claim is that it includes but is not limited to the jury misunderstanding the presence of the third parties and confusing the issues to be decided. Now I think if we deem jurors smart enough to decide the outcome of a case, we should be able to reasonably conclude that they're smart enough to understand instructions and explanations. But she claims juror confusion is especially significant here. I think the jurors are going to have bigger questions concerning Greg Roman than whether or not he indemnified the PIs. She brings up a forum issue and a statute of limitations issue. The forum issue because, as mentioned, he's from Philadelphia, and then brings up the 4.5 years old again, which really makes me mad every time she mentions it because of how much time was wasted by defense, how they blocked them at every turn, and then go and throw it in their faces. They kept discovery wrapped up, claiming it was privileged, and it's just now become available to plaintiffs and other defendants. So this just irritates me so bad. Then she says given the time it will take to litigate these issues, which do not concern either plaintiffs or the Parker's defendants, will cause unnecessary and substantial delay. Why? And they sure didn't mind delaying when they kept trying and trying and trying to get rid of opposing counsel or getting all of these things declared privileged. They had all the time in the world, and now all of a sudden, oh, the delay. And then she says, attempting to locate and serve Roman and company now will exacerbate the potential delay. How? He's not hard to find. He was served a subpoena a couple of months ago. You just said he's in Philadelphia. How is it going to be that hard to find them? Such factors warrant separate trials on the underlying complaint and the indemnification claim and caution against any joinder. That's not what the higher courts have decided, is it? They find it in the interest of judicial economy to put it together. She claims the opposite, that conveniences and efficiencies gained by separating them would outweigh the efficiencies caused by delay of conducting two trials in which some of the evidence presented might overlap. Quoting again from Companion Prop, which is a different situation. Very complex. Nothing like this one. And finally we get to her conclusion, where she admits again that it's unclear under which rule the private investigator defendants seek to assert the proposed third-party claim. Then why are you writing to the court right now for something you don't know? And without knowing, she's assuring the court that the factors discussed above make clear that they cannot demonstrate that permitting the claim is warranted. How can you make that statement when you don't even know what they're going to argue? Defendants have not and cannot justify the joinder because they haven't even filed it yet. Of the proposed third-party claim and the proposed third-party defendants, this court should either deny the claim and instead require the private investigator defendants to pursue such a claim in a separate trial. Oh, Deb. So let's compare what she alleges in this. First point, that it requires written consent of all adverse parties. What the actual law says, it can be granted by leave of the court and is done so regularly. There's an or in there, not an and. 2. Granting this third-party complaint will prejudice Parker parties. She offers only generic reasons that have remedies. It would not extend the scheduling order even. The jury would be confused. Juries can be given explanations. We're past the statute of limitations for this. Indemnity claims are not ripe until liability attaches. So the limits have not begun. And finally, the indemnity agreement designates Philadelphia courts, so South Carolina is improper. South Carolina courts have discretion to decline enforcement if the indemnity clause would split a single controversy into piecemeal litigation. In fact, they favor it to be brought together. Also, if Roman agreed to indemnify South Carolina-based PIs for South Carolina litigation, the dispute could be litigated in South Carolina. So how about next time? Cite better cases and wait till you have the actual motion filed before you respond. Because you're not actually responding. Nothing has happened yet to respond to. And now 3 weeks later, we get the actual motion to amend answer and assert a third-party complaint against Greg Roman and Gravitas Synergy Solutions, LLC. And here it is in its glory. And we see that they move under Rules 14 and 15, not 19. This could have saved Miss Deb a lot of trouble, but hey, when your client's a billionaire, who's counting billing hours? He repeats Rule 14, but we're very familiar with that now, so we don't have to go over that, other than stress that it's by leave of court or by written consent. The written consent part is not required. He tells the court that they seek to amend to assert an affirmative defense and third-party complaint based on information which has only recently been revealed through the discovery process. This is newly discovered information. It's viewed differently. How did it come about? Subsequent to a court order compelling production, an agreement with the proposed third-party defendants was discovered. The third party that the defendants desired to assert a claim against signed a contract to indemnify defendants for claims described in the complaint. And this is how short and sweet it is. He says these are claims that are described in the complaint, so no one's going to suffer prejudice. Then he adds, the law's on my side. Any other evidence that may be admissible prior to or at the time of any hearing on this matter will support it. And this is definitely the sort of thing that a hearing most likely will be held about. It may have already been held, I don't know. There's just not as much information on these dockets as there are on the federal ones. But look at how little time he wastes on this. Unlike hers, he signs it. It's also signed and consented to by the Beach family's attorneys. And like I said, there's nothing new on the docket about this yet, so I'm anxiously awaiting how it turns out. But there's one more filing on the docket, and we're going to talk about that in the next episode. It's a move for a protective order about what attorney-turned-defendant Blake Greco was asked during his deposition. That would have been a great deposition to watch. But we'll talk about that protective order next. Till then, this is Cassidy O'Connell saying stay well and stay tuned.